Hello, everybody, and welcome to History/Law Bite number 329, dated December 2nd, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in today. This History/Law Bite is entitled Myers versus United States, 272 U.S. 52, 1926. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. Again, this video is entitled Myers versus United States, 1926. Myers v. U.S., otherwise known, is a historically important U.S. Supreme Court decision on the issue of presidential power to remove officials of the executive branch of the U.S. government without Senate confirmation of such removals. So, to the facts of this case. In 1876, Congress enacted a law requiring that first, second, and third-class postmasters shall be appointed and removed by the President with the advice and consent of the Senate. Thus, through this federal law, a significant impediment was placed on the President's ability to remove these officials from their positions. On February 2nd, 1920, during his last full year in office, President Woodrow Wilson terminated the service of Frank S. Myers, a first-class postmaster in Portland, Oregon. Myers had been appointed to the office in July of 1917 by President Wilson to a term of 4 years. Accordingly, Myers immediately protested his termination and continued to do so until the end of his established term. For the record, the Senate never consented to his termination. Myers engaged in no other occupation or drew compensation from any other service. On April 21st, 1921, he initiated a suit in the United States Court of Claims for back payment of his salary, which would have been from the date of his termination, a total of $8,838.71. Accordingly, Wilson engaged in a recess appointment for the disputed office in the summer of 1920. The Court of Claims ruled against Myers, which in turn led to his appeal to the Supreme Court of the United States. The decision of the Court of Claims largely based its ruling on the fact that he had not, in fact, pursued his claim in a timely fashion. So, the case was originally argued at the U.S. Supreme Court on December 5th, 1923, and re-argued on April 13th and 14th, 1925. Petitioners argued that the judgment of the Court of Claims was in error, as Myers' termination was never approved by the Senate, and therefore invalid. Thus, he was entitled to the back pay for his incomplete term, period. Conversely, the U.S. government argued that the requirement for Senate confirmation for the removal of officers was invalid, as the president's removal of executive officers that were appointed by and with the advice and consent of the Senate under Article 2 of the Constitution was complete. The judgment of the Court of Claims was therefore correct and had to be affirmed in the government's eyes. The court was therefore forced to confront the constitutional question in Article 2 and examine its history. So the issue facing the Supreme Court in this case was, does the President of the United States have exclusive power to remove executive officers of the United States that he has appointed by and with the advice and consent of the Senate? And the opinion of the court held, yes, he does. On October 25th, 1926, the court delivered a 6-3 opinion written by Chief Justice William Howard Taft in favor of the United States. Taft's opinion placed heavy emphasis on the history behind Article 2 of the Constitution and the plain language contained therein. it is as follows. First, Taft addressed the portion of the opinion handed down by the Court of Claims, which held that the petitioner was guilty of laches, or unreasonable delay in making an assertion or claim, such as asserting a right, claiming a privilege, or making an application for redress, which may result in refusal. As Myers had indeed pursued redress for his termination immediately after it was initiated, this part of the Court of Claims' decision was reversed by the Supreme Court. Number 2, Section 6 of the Act of July 12, 1876, providing that postmasters of the first, second, and third classes shall be appointed and may be removed by the President by and with the advice and consent of the Senate, shall hold their offices for 4 years unless sooner removed or suspended according to law, is unconstitutional in its attempt to make the President's power of removal dependent upon the consent of the Senate. Number 3, the President is empowered by the Constitution to remove any executive officer appointed by him and with the advice and consent of the Senate, and this power is not subject in its exercise to the assent of the Senate, nor can it be made so by an act of Congress, hence why the section of that law was unconstitutional. Number 4, the provision of Article 2, Section 1 of the Constitution, that the executive power shall be vested in a president, is a grant of power and not merely a naming of a department of the government. Number 5, the provisions of Article 2, Section 2, which blend action by the legislative branch or by part of it in the work of the executive, are limitations upon this general grant of the executive power, which are to be strictly construed and not to be extended by implication. Number 6, it is a canon of interpretation that the real effect should be given to all the words of the Constitution. Number 7, removal of executive officials from office is an executive function. The power to remove, like the power to appoint, is part of the executive power, a conclusion which is confirmed by the obligation to take care that the laws be faithfully executed. Number 8, the power of removal is an incident of the power to appoint, but such incident does not extend the Senate's power of checking appointments to removals. Number 9, the accepting clause in Section 2 of Article 2, providing, but Congress may by law vest the appointment of such inferior officers as they may think proper in the President alone, in the courts of law, or in the heads of departments, end quote, does not enable Congress to regulate the removal of inferior officers appointed by the President by and with the advice and consent of the Senate. Number 10, a contemporaneous legislative exposition of the Constitution when the founders of our government and framers of the Constitution were actively participating in public affairs, acquiesced in for so many years, fixes the meaning of the provisions so construed. Number 11, upon a historical examination of the subject, the court finds that the action of the First Congress in 1789, touching the bill to establish a Department of Foreign Affairs, was a clean-cut and deliberate construction of the Constitution as vesting in the President alone the power to remove officers, inferior as well as superior, appointed by him with the consent of the Senate. That this construction was acquiesced in by all branches of the government for 73 years, and that subsequent attempts of Congress through the Tenure of Office Act of March 2nd, 1867, and other acts of that period to reverse the construction of 1789 by subjecting the President's power to remove executive officers appointed by him and confirmed by the Senate to the control of the Senate or lodge such power elsewhere in the government were not acquiesced in, but their validity was denied by the executive whenever any real issue over it arose. This court has recognized in United States v. Perkins that Congress may prescribe incidental regulations controlling and restricting the heads of departments in the exercise of the power of removal, but it has never held and could not reasonably hold that the excepting clause enables Congress to draw to itself or to either branch of it the power to remove or the right to participate in the exercise of that power. To do this would be to go beyond the words and implications of that clause and to infringe the constitutional principle of the separation of governmental powers. Assuming the power of Congress to regulate removals as incidental to the exercise of its constitutional power to vest appointments of inferior officers and the heads of departments, certainly so long as Congress does not exercise that power, the power of removal must remain where the Constitution places it, with the President as a part of the executive power in accordance with the legislative decision of 1789. Whether the action of Congress in removing the necessity for the advice and consent of the Senate and putting the power of appointment in the President alone would make his power of removal in such case any more subject to congressional legislation than before is a question not hereto decided by this court and not presented or decided in this case. Congress is only given power to provide for appointments and removals of inferior officers after it has vested, and on condition that it does vest their appointment in other authority than the President with the Senate's consent. So, the summary, the sum of all of that, is that the history behind and construction of the relevant language in Article 2 of the Constitution only requires Senate confirmation of executive branch officials, purely executive branch officials, upon their appointment, not their removal. Okay? The power to remove purely executive branch officials from their positions, and I mean ranking officers of the executive branch, lies exclusively with the President, and Congress does not have the authority to inhibit the President's constitutional authority in this arena by federal law. Therefore, Section 6 of the 1876 law was unconstitutional. So, Taft's majority was joined in full by Justices Van Devanter, Sutherland, Butler, Sanford, and Stone. 3 dissents were also filed in this case by Justices Holmes, McReynolds, and Brandeis. A rare trio indeed, especially if you know anything about the relationship between Justices McReynolds and Brandeis. By contrast, Brandeis and Holmes were usually always on the same side in cases, whether it be in dissent or the majority. Nonetheless, all 3 entirely disagreed with Taft's logic, reasoning, and constitutional arguments here. Justice Oliver Wendell Holmes wrote a short but biting paragraph and a half dissent where he asserted that the Postmaster General's office of and in itself was created by Congress and depended on Congress for its funding, existence, and other meaningful regulations. He could not accept Taft's opinion that Congress was forbidden by the Constitution to also set the specific regulations as it saw fit on the removal of the Postmaster Generals themselves. Okay? Justice James McReynolds wrote a 62-page dissent providing extensive historical quotes and references from the Constitutional Convention on Presidential Authority. McReynolds strongly noted that nothing in the Constitution, nor any references from the framers, suggested that the President was to have limitless power to dismiss all appointees in the federal government except for judges. And Justice Louis Brandeis also authored a dissent referencing constitutional language, case law, legal precedents, and federal law, which disputed Taft's majority opinion, deferring heavily to broad presidential power to initiate dismissals without any oversight. So the judgment of the court here, the United States Court of Claims, was affirmed, and Myers lost his case, having based it upon an unconstitutional law. The laws referenced in this case, Article 2, Section 2 of the United States Constitution, and other relevant case law. So the legacy and interesting particulars of this case, Myers versus United States, this case stands as a strong precedent with respect to presidential removal of purely executive branch officers exercising executive branch functions. The Supreme Court, however, has sustained the ability of Congress to create independent agencies run by principal officers appointed by the president who cannot be removed arbitrarily, but only for good cause. See Humphrey's Executor versus United States, 295 U.S. 602, 1935. Officers covered by the Humphrey's Executor decision, however, tend to be in performance of quasi-legislative or quasi-judicial roles, not those purely executive as covered by Myers. And another thing, the author of Myers, Chief Justice Taft, had, of course, served as the 27th President of the United States of America. If you didn't know that, from 1909 to 1913, one-termer. And thus, obviously, Chief Justice Taft was more knowledgeable than any other member of the court at this time on executive branch matters. I mean, he, after all, was the President of the United States at one time. So, even though his own presidency was more than a decade and a half behind him at the time of the Myers decision, Taft certainly understood firsthand the president's need to be able to replace executive officers at will. They were, after all, an extension of the executive himself and needed to be replaced quickly, without dealing with the Senate, should the need arise, all right? So this was a no-brainer for Taft, and almost certainly why he kept this opinion for himself, all right? So once again, summary of the Myers decision, the history behind and construction of the relevant language in Article 2 of the Constitution only requires Senate confirmation of executive branch officers on their appointment, not their removal. Okay, the power to remove purely executive branch officers from their positions lies exclusively with the President of the United States, and Congress cannot inhibit the President's constitutional power in this area with mere legislation. All right, therefore, Section 6 of this 1876 law was therefore unconstitutional by requiring Senate confirmation for the dismissal of postmaster generals. All right. So that pretty much sums up our video here on Myers versus United States. If you have any questions or controversies, please leave them down below. I'll be happy to answer them. If you like this video, you learned a thing or two from it, gained some insight, drop me a like, and that'd be greatly appreciated. And if you have not done so at this point, please subscribe to my YouTube channel, Juarez Lee Shelton, MA. Your support allows my channel to grow. And if you wish to financially support my channel, as this is certainly another vocation for me, teaching is no easy thing, and it is certainly no easier to present the information in a concise manner so that it is easily understood. So if you want to support me in that way, please feel free to do so. There are links provided on my page. So again, I thank you so much for listening and hope you learn something and take something from this video today. So I want you to take care, stay safe out there, and I'll talk to you at the next bite. Peace.